Okay, well, hello everybody, and thank you for joining us today for the second session of Venable's Virtual Ad Law Symposium webinar series. This series will cover current trends, topics, and developments in the advertising industry, including NAD regulation, privacy developments and enforcement trends, and FTC enforcement priorities in the new administration outside of privacy and data security enforcement trends. Today's session will cover what advertisers need to know about privacy and predictions for 2021 and beyond. My name is Reed Freeman, and I'm a partner at Venable, and I'm joined by Lou Maestria, the Executive Director of the Digital Advertising Alliance. Let's move to the next slide. Okay, so today's session is eligible for CLE credit. The code for obtaining CLE credit will be given during the presentation, and feel free also to submit questions to us using the Q&A function within the webinar platform. It may be that we can't answer all of your questions live during the presentations, but we'll be happy to follow up with answers to your questions once the webinar has concluded. Let's move to the next slide. Okay, so let's get started. We're going to begin with the current makeup of the Federal Trade Commission and how it is in flux right now. We have an acting chair, Rebecca Kelly Slaughter, who has been a very active dissenter and concurrer in when she was in the minority under the Republican administration. She's acting chair. She may be made the full-time chair, but that's not been decided. Rohit Chopra is nominated to lead the Consumer Financial Protection Board and will be replaced by the president. There is an open seat that the president has nominated Lena Kahn, a professor at the Columbia University School of Law. The significance of Lena Kahn. By the way, all these slide portions that are in blue are linkable for you, so you can see. This is a signal to the tech community that, along with several others, that the Biden administration intends to scrutinize big tech in a pretty significant way. Lena Kahn is a young lady, and she, although she graduated from Yale in 2017, is a real rising star in the antitrust bar, and she made her name writing this paper on modernizing the antitrust laws while in law school, and it was a very well received, and it was a really different take on modernizing privacy laws for where we are now. Commissioners that are Republican commissioners that will stay are Christine Wilson and Noah Joshua Phillips. So we will have 3 Democrats and 2 Republicans once the president is done with his nominations and the Senate is done confirming the nominations. Let's move to the next slide. Okay, so the Federal Trade Commission has for years called for federal privacy legislation. Let's move to the middle of it. Commissioner Slaughter, who's the acting chair, I've highlighted in yellow the real key points. The need for comprehensive data privacy legislation with meaningful limitations on the collection of data and prohibitions on discriminatory practices, dark patterns, which we'll talk about in a while, and data abuses has never been greater. Commissioner Phillips would like to see more data security legislation, and Commissioner Wilson wants federal privacy legislation that is something that is concrete enough and understandable enough and simple enough for businesses to follow. Interestingly, business is not opposed to federal privacy legislation. What business wants is federal privacy legislation that they can actually comply with. And the sticking point, as we'll see through as we get through this, is that is preemption of state laws, which Democrats are opposed to and Republicans are typically not, and a private right of action, which Democrats typically like and Republicans typically don't. The call for legislation by the FTC has been ongoing for many, many years, and what they would like in general is a couple of things. They would like in what's called Section 5 cases, when it's not under a rule or the enforcement of an order, they would like the ability to have civil penalties in the first instance. Right now, they do not have the authority to assess civil penalties under a Section 5 unfairness or deception case in the first instance. They would like that. They would also like their rulemaking authority to be made more simple, and they would like to be given more rulemaking authority. And they would like to then promulgate rules and bring enforcement. We'll see what their priorities are in enforcement moving forward. So let's go to the next slide. All right, so the current privacy bills in Congress right now that are pending now are the Promoting Digital Privacy Technologies Act, which is simply just to support research on privacy, what we call PETs, privacy enhancing technologies. The Information Transparency and Personal Data Control Act and the Data Care Act. In each case, those bills would have no private right of action, but also no preemption. And then there's a Senate resolution urging the European Parliament to exempt certain technologies used to detect child sexual exploitation from European Union, the European Union e-privacy directive. Now, there are bills that will be introduced in Congress that come from prior Congresses that have not yet been introduced that will give the FTC rulemaking authority, that will give the FTC a civil penalty authority in the first instance, and that will allow for a private right of action. They've not yet been introduced, but we'll see how it goes. As we'll see going forward, there are a number of state bills pending and Virginia passed, the CPRA passed, other bills may pass. I think the fulcrum on which federal privacy legislation sits on is if we get 5-6 state bills on the same issue, privacy, that are different and significantly different enough so that they make it difficult for businesses to act on a nationwide basis, which will sort of force the issue. And until then, I think we are going to be stuck with the state legislation that we currently have until it becomes untenable. And so let's move to the next slide. Okay, so The FTC has a number of initiatives in privacy they uh, that they have announced. There is a dark patterns workshop. You can click on the link and see what they're after, but it's essentially what they're calling dark patterns is essentially web practices that trick people into things that they don't expect. They're holding their annual Privacy Con on July 27th. That's where they gather stakeholders from academia, from business, and from the advocacy community to present papers, to discuss issues. It's an annual event. And the acting chairwoman, Rebecca Kelly Slaughter, has announced a new rulemaking group where they're going to use their existing rulemaking authority to try to make new rules. Now, a note on that: in the 70s, the FTC went a little past parallel with rules, and so much so that they upset Congress, and Congress took away their APA rulemaking authority and stuck them with what's called Magnuson-Moss rulemaking authority, which is extremely burdensome for the FTC, extremely time. It takes a lot of time and a lot of work, but the acting chairwoman does want to use what she has now to promulgate rules until they get Administrative Procedures Act rulemaking authority from Congress, which is much easier. So we can move to the next slide. Okay, FTC initiatives still. These are all blog posts that you can click on and read. They're very, very helpful. They were written by Andrew Smith, who's no longer the director of the Bureau of Consumer Protection, but he's a very intellectual person, and he's a very long-standing FTC lawyer. Was previously the head of the FICRA program before he took over as went into private practice and came back as bureau director. So he issued a blog on the new injunctive relief and data security orders so that they're more specific. They increase third-party assessor accountability and elevate data security considerations to the C-suite and the board level. Now, the next one is one that I think everybody on this call ought to print out and keep. This is a issue that the Federal Trade Commission has. This is a complicated issue at the Federal Trade Commission. Third-party liability. That is liability for what we call secondary liability. And in criminal law, it's called aiding and abetting. But the FTC does not have aiding and abetting authority. Under the telemarketing sales rule, they have assisting and facilitating. But Andrew Smith laid out in this really, really excellent blog post all of the theories the FTC has for multi-party liability in an FTC case. It's something I've struggled with to keep up with because it's complicated and a lot of the law is old. This is a refresh. It's really helpful, and for in-house lawyers and for firm lawyers, this is just a terrific resource. Then he issued a blog post on using artificial intelligence and algorithms, and it talked about the FTC's enforcement action studies and guidance, emphasizing that the use of AI tools should be transparent, explainable, fair, empirically sound, while fostering accountability. Andrew Smith, again, I said, was a FCRA person, so he was particularly concerned about the use of artificial intelligence and algorithms for credit or insurance or employment under the FCRA. So we can move to the next slide. All right. We are in a we are in a position right now where we talked earlier about the FTC cannot get civil penalties in deception and unfairness cases in the first instances. What they could get since 1982, when the first decision came out, was the full slate of equitable remedies in these what we call 13B cases. Let's go back to the previous slide. In 13B cases, which are just cases brought in under Section 5. And for years, that was taken as granted that the FTC could get the full slate of a preliminary injunction, a TRO, an asset freeze, a receiver, and equitable monetary relief in the form of restitution and disgorgement to the Treasury. The Ninth Circuit in AMG Capital Management said it was bound by precedent that Section 13B authorized equitable monetary relief, but the Seventh Circuit held that the FTC does not have the authority to obtain monetary restitution under Section 13B because it is not specifically authorized under the statute. Now, they're still seeking it, but it's at the Supreme Court, and we'll see how that plays out. It may be overridden by legislation later, but until then, we'll see what the Supreme Court says. And it would be a crippling blow to the FTC if the Supreme Court held, and remember, it's a conservative Supreme Court that we have now, that the FTC could not get equitable monetary restitution in 13B cases. So let's move to the next slide. Okay, so this is just for your to keep. These are the rules and guides that are currently under review. The Federal Trade Commission has a periodic review of their rules. The COPPA rule is under review. I don't expect significant changes to the COPPA rule. We had a huge change to the COPPA rule in 2013, which took account of online IDs and the modernized COPPA. I don't expect much there. The financial privacy rule, the GOBA privacy rules under review, the safeguards rule, health breach notification rule, we'll come back to that, the affiliate marketing rule, identity theft rules, and then, and just in case you were wondering, they're doing MAGMOS rulemaking on the eyeglass rule and the funeral industry practices rule, one of my favorites. Let's move to the next slide. All right. So now let's take a peer into the future of what a Democratic Federal Trade Commission led by a Democratic chairwoman or person may be Commissioner Slaughter or someone else, but certainly Commissioner Slaughter will have a significant say, having been an acting chair and a commissioner before that. I want to, the first bullet says FTC investigations should determine involvement of senior executives, and enforcement teams should evaluate whether naming corporate executives will achieve specific and general deterrence. Let me pause there for a moment and say, in cases involving small, closely held corporations, it's routine for the FTC to name corporate executives. And the reason why is that in small, closely held corporations, the theory that the FTC has is that if they don't name the executives and sometimes management, then all they need to do is go and create a new entity, and they won't be under order, and the FTC won't be able to get civil penalties for violating the order. It is extremely rare. I'm only aware of 2 cases where the FTC has named corporate executives in publicly traded corporations. So this would be a sea change if the FTC names corporate executives in cases involving publicly traded corporations. That's a sea change if that's the way they go. Remedies should require greater transparencies from companies by requiring that data privacy assessments be made public and requiring public reporting of consumer complaints and company responses. There are a lot of issues with that, including data privacy assessments and whether they were done under privilege. That's an issue to be concerned about. Data privacy enforcement efforts should be focused on AI decision making. So there's a priority. The use of data to increase levels of child and teen engagement on social media platforms. There's a priority. We've talked about using its existing Magnuson-Moss rulemaking authority to make rules until they get Administrative Procedures Act authority. And the FTC should seek 2 types of relief in privacy cases, and 1, meaningful disgorgement of ill-gotten monetary gains, and 2, effective consumer notice of the order. This would be new types of relief, new what we call boilerplate in orders, and meaningful disgorgement of ill-gotten monetary gains says to me that they don't think they're getting enough so far, and we'll see later on that's what they think. And then another priority, the FTC should aggressively use COPPA and General Section 5 authority to protect student privacy. So there are some things to look out for from the acting chair for looking into the future and priorities. And we can move to the next slide. This is Commissioner Chopra, who will no longer be there, but nevertheless, I suspect that what he has said in his dissents and concurrences will be taken up by the FTC under democratic control. So the first bullet, he proposes requiring forfeiture or deletion of any algorithm developed with ill-gotten images to stop improper collection of biometric information. So the FTC facial recognition, biometric information. Next slide, next bullet talks about unlawful facial recognition practices. So I can expect the FTC to focus on facial recognition. Then let's move to the second to last slide. focusing more enforcement on the FCRA, Fair Credit Reporting Act, which he says can be a powerful weapon with which to combat housing discrimination stemming from errors and inaccuracies. And I think that's actually under-inclusive, not just housing discrimination, but also discrimination in credit and in insurance and employment. The FTC should write rules to ensure there's accountability for undisclosed influencer connections and deceptively formatted ads, which is probably something you'll hear more about tomorrow. Let's move to the next slide. Commissioner Wilson, this Republican, she is very concerned that the FTC bring cases and have an enforcement regime that is predictable for business, she encourages the FTC to engage in what's called 6B studies of the practices of technology companies, including social media companies. A note on that: 6B used to be called industry rounds. This 6B allows the FTC to send CIDs to industry to get information in order to make policy or to make enforcement priorities. So they've done it in a number of cases previously, and this is a Republican encouraging it. It's a very burdensome thing for companies to deal with, but nevertheless, you'll have 3 Democrats and a Republican probably in favor of that. Let's move on. Commissioner Phillips is looking at what the Democrats want to do with COPPA and saying, well, let's make sure that we don't expand it so far that it exceeds congressional intent, that it's supported by data and empirical evidence and balances the possibility of harm to children with the potential promise of technology. So typical Republican type thing to say. Advocates for federal privacy legislation because of the patchwork of state legislation. We can move on. Again, peering into the future from another angle, which is the cases the FTC has brought in the last couple of years and the concurrence and dissents of the Democrats. So the first is Flow Health. Their alleged violations of the Federal Trade Commission Act and Privacy Shield principles by sharing users' health information with outside data analytics providers after promising, let's move back. Okay. After promising such information would be held private. Remember, these are allegations. There was no monetary settlement, just injunctive relief. Both Commissioners Chopra and now acting Commissioner Slaughter concurred with the requirement to notify consumers that Flow Health had been charged with sharing information with consumers without consent, but they dissented in part because the complaint did not allege violations of the health breach notification rule. So another FTC priority that they're looking at. In the matter of Everbloom Inc., the FTC alleged that Everbloom deceived consumers about use of its facial recognition technology and its retention of the photos and videos used of users who deactivated their accounts. It was a non-monetary settlement, just injunctive relief. And Commissioner Chopra issued a statement. He agreed with the requiring deletion of facial recognition technologies, but the lack of a penalty, he said, was unfortunate. He would have liked to have seen I guess, disgorgement to the Treasury, or which would have been the only remedy available, because I think it would have been difficult to calculate restitution in that case. He says the FTC should restate precedent into a rule under the Section 18, which is the civil penalties section, so it can seek penalties and other relief when the FTC first discovers the alleged violation. So again, the FTC calling for civil penalties under deception and unfairness allegations in the first instance. And we can move to the next slide. In the matter of Ascension Data and Analytics, alleged violations of the Gramm-Leach-Bliley Act safeguards rule by failing to ensure one of the firm's vendors was adequately securing personal data. So a note on that, again, it's very important that this is a company being held liable for the actions of its vendors by failing to adequately monitor them. There's a non-monetary settlement with a comprehensive data security program, biennial data security assessments, but Commissioner Chopra argued that the order failed to bind the right parties, such as others within the same corporate family, and that the complaint should have included an unfairness allegation. So again, note, FTC is looking for more unfairness cases. A note on that, deception, the elements of deception are an act or practice that is likely to mislead consumers, reasonable consumers, to their detriment about something that is material. Unfairness is an act or practice that causes substantial consumer harm that consumers are unable to an act or practice that causes substantial consumer harms that consumers cannot reasonably anticipate. So we can expect more unfairness. FTC looking for more unfairness cases. Unfairness does not require deception. It just requires an act or practice that causes substantial harm, not outweighed by consumer benefits or competition. Appfolio involved the alleged violations of the Fair Credit Reporting Act for failure to ensure the accuracy of reports about potential tenants in housing. The concurrence of Commissioner Slaughter supported the penalty and the FTC's aggressive use of its rules and civil penalty enforcement authority. But in the future, she thinks that the consumer reporting agencies should be required to pay back victims when they violate the act. The dissent of Commissioner Chopra argued that given the widespread harmful conduct that was alleged, the FTC should have only agreed to a settlement with victim redress and should have sought more specific safeguards to prevent recidivism or doing it again. So again, higher penalties and more aggressive enforcement of the FCRA. So we can move to the next slide. All right. In the matter of Zoom, the FTC alleged that Zoom misled consumers about the level of security provided and compromised the security of some Mac users. Of course, we're using Zoom now. I kind of feel bad for Zoom because COVID hit and all of a sudden everybody was using Zoom and Zoom got sued. There was a non-monetary injunctive relief settlement on a data security case, which is typical now. But the dissent of Commissioner Slaughter, now acting chair, argued that the order did not address the alleged failures and did not require Zoom to provide any recourse to affected users. That means money. So they would like to see money in data security settlements, which would be new. The dissent of Commissioner Chopra disagreed with the settlement because he said it was weak, providing no help, no notice, no money for victims, and no meaningful accountability for Zoom. So what does that tell us? The FTC thinks that the current data security orders are not strong enough. They should involve stronger injunctive relief and monetary relief. And in the matter of NTT Global Data Center Americas, it was a USEU Privacy Shield framework case. Notably, that although that was struck down by the European Court of Justice, the FTC is still bringing cases against companies that are still Privacy Shield certified if the FTC finds that they're not living up to their Privacy Shield certification requirements. The dissent of Commissioner Chopra argued that the settlement failed to meaningfully hold NTT accountable with no fine, no help for victims, and no admission or findings of liability. So again, way more aggressive. Whether the FTC is ever going to change its orders to require an admission of liability is, I think, kind of up in the air, because I don't think businesses are going to want to sign orders admitting liability. That would be new. That would be a new and a very substantial change to existing practices. So we can move to the next slide. I think this is the last peering into the future slide. This is the Google YouTube case. $170 million civil penalty for alleged violation of the Children's Online Privacy Protection Act and the FTC's COPPA rule. Commissioner Chopra argued that the penalty should have been higher. $170 million is several orders of magnitude higher than any other COPPA case, yet we have a commissioner arguing that the penalty should have been higher, and that the executives avoided scrutiny, and whereas small companies pay dearly, executives are often named in consents. Well, that's not true. Executives are often named in consents in small, closely held corporations. Naming executives in publicly held companies would be rather new. The dissent of Commissioner Slaughter argued that the FTC should have required YouTube to police the channels that misdesignated their consent, such as by requiring a technical backstop to identify child-directed content. So it was a more targeted dissent. But I mean, you have here a Democratic commissioner saying $170 million is not higher, and we should have named the executives of Google, which would be new. So we can move to the next slide. And Lou.
So thank you, Reed. I want to thank you for having us here today. Thank our friends at Venable. I'm Lou Mastria. I'm the executive director of the Digital Advertising Alliance. Many of you are friends, or we've known each other throughout the years. And I can't thank Reed and the rest of DA's counsel at Venable for all their help throughout those years. It's wonderful to be here and listen to Reed a little bit, look and to learn a little bit more about this dynamic space that we're all in. And hopefully I can offer a few insights to go along with Reed's on how industry has is and is working to respond to some of the seismic changes that are happening even as we speak. Here on this slide, I meant this as a little bit of a background, a little bit of overview. We sometimes forget this, but we as an industry have oftentimes, many times over many years and decades, responded to various concerns in the ecosystem from consumers. And here you can see a catalog that we quickly put together, reaching back from 1960 to basically today, that shows how industry has responded with everything from ethics codes that were developed by what used to be the Direct Marketing Association back in the 60s, and forward to the program that I run today, which started about 10 years ago, the Ad Choices program, and all the developments with that, including some of the things that simply weren't on our radar when Ad Choices started. When we started, it was very much a transparency control program, assumed to be on desktop web, assumed to be about cookies, assumed to be about various other things. But as concerns changed, as the ecosystem changed, and priorities for marketers and businesses who were looking to grow changed, the program evolved as well. And so I think it became clear fairly early on about some of the reasons to put in place prohibitions or ways to get consent if there are sensitive categories, to have a heightened level of consent around those kinds of categories, creating a system for allowing consumers to opt out, not just of cookies, but also of non-cookie technology as it was understood about 4 or 5 years ago. Then moving forward into the app environment, moving forward into new areas that marketers saw as growth areas, making sure that all of our resources and tools were available not only in English, but also in the fast-growing and important native Spanish speaking market. And then obviously as new tools launched, as new compliance regimes launched, notably with CCPA, making available tools in that arena. And that is a little bit, again, of an overview to show that industry has and continues to be very active in terms of how it responds to what it sees in the market as concerns. And so as we turn to the DAA program as kind of an example of that, I wanted to point out some of the ways we think of the Ad Choices program today, nearly a decade into its existence in market. And what are some of the numbers that we can assign to that? And this is less about DAA bragging. This is much more about a reflection on you all and some of the incredible efforts that you all have put out over the past decade to make sure that you are adhering to what we've agreed to are responsible steps by the advertising industry to make sure that you're being proactive with your consumers about their privacy, being proactive with them about their data collection, about what kind of choices they have. And so these numbers are really a reflection on you. These are really a reflection on the good work and the good intents of all of you. And they, I think, reflect well when we go talk to folks on Capitol Hill or other key lawmakers and regulators, FTC included. Don't forget that the DAA really did launch in part in working with the FTC after a report that they issued in 2009. So where we stand today is thousands of brands participating with the program. That means that 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 icon is ubiquitous. It's literally everywhere, and you'll see in a minute that we've done some consumer polling, and that is in fact one of the things that we hear from consumers. Consumers come to our site to learn about what are the choices that they have, what are some of the actions they can take to control their data collection and use. And so not too long ago, we eclipsed our 100 millionth unique visit to our sites. And so that is a bit, again, a testimony to the responsibility that this industry shows. Today, we have companies on our Web Choices tool and our App Choices tool, which offer consumers those choices. And the icon itself is being delivered at a rate of eclipsing 1 trillion times a month globally, which is no small thing. Don't forget, for those of us who are a little bit long.
Lou, we lost your audio. And while we're waiting for that to come back, let me say that for CLE purposes, there's a code word, and it is Privacy 2021. So again, the code word is Privacy 2021, and just there's no spaces in the middle, no worry about caps. Privacy 2021. Thank you.
Okay, so I think I'm back on. Reed, please tell me if I'm not.
You are.
Great. So as we think back to that time when real-time notice was really a privacy wish, you all have really taken that and run with it. It's, in some ways it is kind of that privacy enhancing technology that Reed referenced earlier. This was simply not a thing that was practical at that time. But here we are, trillions upon trillions of ads, consumers constantly getting the ability to exercise by clicking, just get information about what data is being collected, how an ad got to them, and then possibly making choices about that. That simply was not in the ether at that time. And so we are certainly very far along in that conversation. Importantly, too, one of the other novel and unique elements that DAA brought when it launched was independent enforcement and accountability of its principles. This was, again, a novel area for self-regulation. Self-regulation had, at that time, generally been thought of as a member-driven proposition. DAA approached this very differently, and it's a testament to folks like Stu Ingus from Venable and others, our trade association partners at the ANA, the 4As, what used to be the DMA, IAB, NAI, AAF, to come up with this idea that that the DAA would effectively look at the market based on practices, not on membership, and would have an independent accountability arm. And that independent accountability arm has been fairly active. It's got 125 publicly announced compliance cases. Again, this is different from the FTC knocking on your door or somebody else. We try to bring companies into compliance with the industry standard rules, but it is a notable achievement to say that there have been this many compliance actions. I joked with someone at a cocktail party, I guess it was pre-pandemic at this point, there are probably nations who haven't achieved that kind of level of compliance action activity, but that's true. So as we look at achievements like that, and those cases are both in the U.S., internationally. They involve first parties, third parties. They involve apps, websites, precise location data, software development kit providers, sensitive data, cross-device, video, political ads. They really have run the gamut of all the things that DA has been asked to look after over the years. So this kind of monitoring complaint-based system continues to be one of the most unique and one of the, I think, best solutions that we have, as an industry, have come up with for making sure that we continue to act and continue to show that we are, in fact, a responsible industry. So we talked a minute ago about the ubiquity of ICON, and there is no small reason for that. The reality is that all of you, and working with all of your partners and so on, display the ICON a lot. That trillion a month rate, which we had seen, does in fact make an impact. And so when we poll consumers, and we did this year, but this is very much in line with some polling that we had done in 2017, 2016 as well, that a lot of consumers say that they recognize the Ad Choices icon. This year, we got an 82% number, which is a really terrific number, particularly for companies that are themselves working through how to have, candidly, what can be a little bit of a challenging conversation with the consumer about privacy. And so having this consumer-friendly, consumer-recognized helper brand, quote unquote, as some have called it, is a way to facilitate that, to give the consumer information in real time, anytime that the consumer wants it. It's available to him or her to be able to make some decisions. And I think that this is that kind of framework has in fact turned into an asset for brands and publishers. We see that those branded messages around privacy have increased trust from the consumer. When the consumer sees the icon associated with a brand or publisher, 73% of them say that their sense of trust increases through that interface. And so that is a terrific testament, again, for a program that you all continue to support, continue to help move forward as we make our way into our 10th year, really, of accountability. And so you can see additional statistics there that have to do with the recognizability, the utility, the easy to understand nature of the ICON program and how you all have implemented it over the years. But importantly, too, and this is one of the things that I think gets overlooked, but is an important stat, is, and it's not on this slide, but I often talk about it. Whenever we ask consumers, hey, does digital advertising actually help you? Over 80% of them say that they actually have found a new product or service via digital advertising. In the policy debate, that often gets lost, but that level of competition is inherent in what we're doing, and hopefully the Ad Choices program is part of helping you do that. I did want to touch on one more thing before I turn to Reed to talk to a couple of questions, and that is, as we think about the industry responding to some of the challenges in the ecosystem, here what you're looking at is from the Privacy for America framework that we launched about a little more than a year ago. to try and bring a level of predictability and a level of certainness to the landscape as we started to see more and more states get into the privacy debate. And so this is from the framework as we launched it. Obviously, this is a very fluid and dynamic environment. And so talking to folks like Reed or his colleagues, Stu Ingus, Mike Signorelli over at Venable, will give you a better sense for where this stands at the moment. But the reality is, again, as we think about how industry has responded over the many decades, this is yet another initiative to try and be on the right side of the consumer and to provide a level of predictability and a level of a base level of trust for you to grow your businesses. So with that, I'm going to stop and turn it back over to Reed. Reed?
Thanks, Lou. I think you have a question on the DAA, which I don't see, but maybe somebody could repeat it for us, and then you can take it, and I'll take the rest.
Sorry about that. I was futzing with my microphone. So the question for those of you who can't see it is how the DAA program extends beyond cookies to other identifiers. So in each case that the industry has moved to adopt new identifiers, DAA's moved with industry. And so as I said, originally, it was basically assumed, hey, cookies only. Then probabilistic identifiers into the market, and we made our opt-out tool, our web choices tool, available in 2017, such that it could send an opt-out request both for cookie-based identifiers as well as probabilistic identifiers. 2014, we also made available an app that allowed consumers to opt out of identifiers in the mobile space. So IDFAs and GAIDs were available suddenly to consumers to say, no, please opt me out of this. And even as we speak, we're looking at what are the future types of identifiers that marketers are going to need to use inside their systems for efficiency, effectiveness, attribution, all the kinds of things that, including targeting, that are going to be important for their growth. And how do we afford consumers a centralized way to make choices around those? And so we are looking at that right now in terms of those new identifiers that are coming to the market. So if you'd like to know more, happy to drill down deeper, but I want to turn it over to Reed because I know there's a few other questions.
All right. Well, thank you, Lou. So the first question is there any indication that nonprofits will be exempted from legislation? The answer is currently the FTC Act exempts nonprofits from the FTC's jurisdiction. The FTC, in its call for legislation I left out, they would like to include nonprofits within their authority. So right now, nonprofits are exempted, but the FTC wants that to change. The next question is to repeat the code. The code is Privacy 2021. You do not need to capitalize anything, and you do not need to have any spaces. Privacy 2021. The third question I have here is I would be curious to hear more about online behavioral tracking and the sale of information I can't read with my glasses on, information to ad tech networks and the status under the CCPA, particularly as it relates to how privacy policies are drafted. Okay, so, well, this is a two-part answer. the CCPA defines sale essentially as the providing of information. The law says sale means the providing of information for any form of consideration. I take that to mean providing information to anyone for anything that involves a business purpose uh, at all. So, online behavioral tracking and the sale of information to ad tech networks and the status under the CCPA. A lot of it's not settled. The AG has not brought a case on it, but the a lot of companies in the industry believe that the transfer of information in the chain that is the ad tech chain does in fact involve the sale of information and requires a do not sell my personal information. Not everybody, but it's not a subtle question, but a lot of folks do. And I hope that answers your question. If you have a follow-up, please let me know. And we have one more question. What time does this go to? Well, we're done. We'll wait a minute and see if anybody has any additional questions. And then again, I'll then close. I'll just wait for, I would guess, maybe 30 seconds to see if anybody has another question that they'd like to type in.
Reed, while we're waiting, if you don't mind, if I could follow on that CCPA question. So DAA has made some resources available on its site for understanding and managing that inside the ad tech space. So if anyone is interested, please feel free. You can go to digitaladvertisingalliance.org/CCPA resources. I'm sorry, that's a long URL. Otherwise, you can just send me an email and I'll point it back to you. But we do have some resources on how to handle that. So,
and I did say it's a two-part question. The CPRA will replace the CCPA in 2023, and it takes sale and ads sharing to make it clear that sale is not just sale for monetary or other valuable consideration. Any kind of sharing is involved. So with that, and with no further questions, I want to thank you for joining us for today's discussion. A recording of this session will be made available shortly on our Venable website. We hope you'll join us for our next webinar and our symposium series taking place tomorrow, and we invite you to visit our blog all about advertising law to stay on top of other industry developments, and venable.com/adlaw to learn more about us or to contact our professionals if you have any questions. With that, I want to say thank you and have a great day.